everyone, and welcome to Know Your Rights, Parental Rights in Early Intervention and Special Education.
Okay, today's objectives, we will share information about where parental rights are found in special education law, where individuals in Maryland can find a description of their rights, give a brief overview of timelines, and highlight key elements in the parental rights document. We encourage all parents to thoroughly review the procedural safeguards document for complete and accurate information regarding parental rights.
And you'll see on the screen, there's a QR code. So as we're going through the presentation, if you have any questions, you can use that QR code, or you can also use the link in the chat box.
The Individuals with Disabilities Education Act, or IDEA, is a federal law that went into effect in 1975 to ensure eligible children with disabilities receive a free and appropriate public education, or FAPE. Part C of IDEA refers to early intervention for students with an IFSP. Part B of IDEA refers to special education for students with an IEP. IDEA mandates that parents of children with disabilities are legally protected throughout the special education process. These protections, called procedural safeguards, are the legal protections of children with disabilities and their parents under the IDEA. The Maryland State Department of Education publishes the Parental Rights Procedural Safeguards Notice. Every parent or guardian of an eligible child should receive a copy of this notice from an early intervention provider or school team member. Every family should be given a copy of the Parental Rights Procedural Safeguards booklet at the first IFSP or IEP meeting and annually for IEP parents. For children and families receiving services through an IFSP, parents are to receive a copy of procedural safeguards, along with prior written notice, including when the early intervention services provider proposes or refuses to initiate or change the identification, evaluation, or placement of the child, or the provision of early intervention services to the child and that child's family. When a child is referred for early intervention services under Part C, or with a copy of the state's system of payment policies when obtaining consent for provision of early intervention services. For children receiving services through an IEP, parents are to receive a copy of the procedural safeguards document. Upon initial referral or parental request for evaluation, upon receipt of the first written state complaint in a school year, upon receipt of the first due process complaint in a school year, when a decision is made to take a disciplinary action, and upon parent request. The Procedural Safeguards booklet can be found by visiting aacps.org. Click the menu tab at the top, scroll down to Specialized Instruction and Early Intervention Services, then click the Parent Resource tab.
The Infants and Toddlers program is on the left side of your screen, information about timelines for that, and then the timelines information on the right side of the screen is for IEPs. And the QR code on this slide will again lead you back to the form to submit questions. So on the left side of your screen, you'll see the Infants and Toddlers program has 45 days from the date of referral to complete evaluations and develop an initial IFSP. For children that are determined eligible, IFSP services must begin within 30 days. And an IFSP is reviewed at least every 6 months and updated as necessary. And for an IEP, we'll look at the right side of your screen. Within 90 days of referral to special education, an IEP meeting will be scheduled to decide if the student needs to be evaluated for special education services. If the team determines an initial evaluation is needed, that initial evaluation must be completed within the 90-day time frame. Parental consent must be obtained before evaluations can take place. If a student is determined eligible for special education services, an IEP must be developed 30 days after eligibility determination. An IEP is reviewed annually, and every 3 years, students must be reevaluated to determine continued eligibility for special education services. Next, we'll talk about the native language, PWN, or prior written notice and consent. Parents have the right to receive information in their native language. A parent may request to have an IFSP or IEP translated into the parent's native language if the native language is spoken by 1% of the AACPS student population. In regards to electronic mailings, a parent may request to have documentation sent electronically to include prior written notice, procedural safeguards notice, and notices related to the request for due process. Next, we'll talk about PWN, or prior written notice. Parents have a right to receive written communication about AACPS's actions concerning their child's early intervention or special education and related services. This written communication is called prior written notice. Parents should receive a notice in a reasonable amount of time prior to the proposal or refusal of initiation or change in the identification, evaluation, educational program, or educational placement of a child. Provision of free appropriate public education or FAPE for a child, for the provision of early intervention services to the child and the child's family through an IFSP, or for the provision of special education and related services to the child through an IEP. For children and families receiving services through an IFSP, written notice must be given in a reasonable amount of time, typically within 10 days, and must describe the action that is being proposed or refused, explain the reasons for taking such actions, and include the procedural safeguards. For children receiving services through an IEP, the written notice must describe the actions that the public agency proposed or refused to take, explain why the public agency is proposing or refusing to take the actions, describe each evaluation procedure, assessment, record, or report the public agency used in deciding to propose or refuse actions, include a statement that parents have protections under the procedural safeguards provisions in IDEA. Tell parents how they can obtain a description of the procedural safeguards if the action that the public agency is proposing or refusing is not an initial referral for evaluation. Include resources for parents to contact for help in understanding the IDEA. Describe any other choices that the child's individualized education program or IEP team considered and the reasons why those choices were rejected, and provide a description of other reasons why the public agency proposed or refused that action. Take a minute. That was a lot of information. Next, we're going to move on to telling you information or giving you information about parental consent. Parental consent must be obtained to assess a child for both early intervention services and special education services and related services, as well as before providing these services for the first time. Parental consent is also needed before additional screenings, individualized evaluations, or assessments can be performed. Parents have the right to withdraw consent at any time. For a child eligible for early intervention services, a parent may determine whether their child, or other family members will accept or decline any early intervention service without jeopardizing other early intervention services. If a parent chooses to continue early intervention services for a child 3 or older through an extended IFSP, an educational component must be included. If the parent does not want the educational component, they are not eligible to receive early intervention services. For a child with an IEP, parental consent must be obtained for the child to be reevaluated. In addition, an IEP team must obtain written parental consent before enrolling the child in an alternate education program that does not issue or provide credits towards a Maryland high school diploma, identifying the child for the alternative educational framework that leads to a certificate of program completion, or to include restraint or seclusion in the IEP to address the child's behavior. That was a lot.
There was a lot. Let's take just a quick minute in case anybody has questions. You can use the QR code to submit questions. So we'll just pause here for just a minute in case you have questions. You can use the QR code that's shown currently on the screen before we move on, because that was a lot of information.
Mhm.
Okay, so we're gonna move on to surrogate parents and the rights of surrogate parents. So in early intervention and special education, a surrogate parent may be assigned to an eligible child if the parent cannot be identified, the parent cannot be found, or if the child is a ward of the state. Reasonable efforts must be made to assign a surrogate parent within 30 days of the need being identified. Now into confidentiality. So parents can expect that AACPS will keep their child's early intervention or educational records confidential. At any time, a parent has the right to request to review their child's record. Dispute resolution. So the Maryland State Department of Education offers 3 processes available to parents and public agencies for resolving disagreements regarding a child's early intervention or special education program and related services, including eligibility. These options include mediation, state complaint, and due process complaint. Mediation is a voluntary process for all parties that may be used at any time by the parents of a child with a disability and AACPS involving any matter under Part B of the IDEA, including matters arising prior to the filing of a due process complaint. Mediation may be requested by parents or the public agency, in this case, AACPS. In addition to mediation, parents have the right to use the state complaint process or due process to resolve disagreements with the public agency. Each of these options has different rules and procedures that are outlined in the procedural safeguards. The parent, early intervention services provider, local lead agency, or a public agency may file a due process complaint on any matter relating to the identification, evaluation, or placement of a child, or the provision of early intervention services or educational placement, or the provision of a free appropriate public education or FAPE for the child. Again, more information about these processes can be found on the MSDE website, marylandpublicschools.org. We would like to highlight the various options for resolving disagreements within AACPS. We encourage and invite parents to first reach out to the school team and/or the AACPS Division of Special Education if there are any questions or concerns about eligibility or the provision of special education services for their child. Parents may request to discuss their concerns in an IEP meeting at any time. Each school team is equipped with a resource team that can help address the various needs of students in special education. Other possible solutions are to contact the school-based team to schedule an IEP meeting to discuss concerns. You can also reach out to us, Partners for Success, if your child is aged 3 to 21. Additionally, the resource team at Birth to 5 Services can be contacted for additional assistance. Resource teams may include academic specialists, behavioral specialists, pupil personnel workers or PPWs, and family outreach specialists like Mindy, who we have with us today.
Absolutely. And we'll take a quick second again to give you a moment to submit any questions using that QR code on the screen.
If a parent of a child with a disability disagrees with an evaluation completed by AACPS, the parent has the right to an independent educational evaluation, or an IEE. The parent has the right to have the child evaluated by someone who does not work for AACPS. Only parents of a child with a disability under Part B are entitled to an independent evaluation. The IDEA provides very specific and detailed procedures and protections for students with IEPs or extended IFSPs. If AACPS takes certain disciplinary actions, AACPS is responsible for providing educational services after a student's removal of more than 10 school days due to violations of the student's code of conduct. For further details about discipline, please refer to the Parental Rights Maryland Procedural Safeguards Notice. IDEA does not require AACPS to pay for the cost of education, including special education and related services, of a child with a disability to a private school. If AACPS made a free, appropriate public education or FAPE available, and the parents chose to place their child in a private school. However, AACPS shall include the child in the population of children placed in private schools by their parents in accordance with the federal regulations. In Maryland, parental rights do not transfer to children with disabilities on reaching the age of majority, which is 18, except under limited circumstances.
And again, we'll give a minute to submit questions in case you need time to do that. So we do know that we provided you with a lot of information today. For more information or to discuss your questions or concerns with an AACPS staff member, please contact any of the following offices listed here. We have the Compliance Office. They can be reached at 410-222-5423. The Birth to 5 Services Office can be reached at 410-424-3260. And the Partners for Success Office can be reached at 410-424-3258. And again, if you need any more information about the Maryland Parental Rights or Procedural Safeguards Notice, you can use the Google that, or the QR code that we placed on the screen before. So we thank you so much for your time today. If you want to submit questions, all of your questions will be submitted, directed to the appropriate office. And you can use this QR code on the screen to do so. So thank you so much for your time today.